Well, good morning, everybody. Neil Foley from the Business Growth Club here. I'm really delighted this morning to have an old friend of mine, Gordon Simpson from Percival here. How are you, Gordon?
Yeah, I'm good, Neil. I'm good. Thanks.
Well, I'm looking forward to today. What we're going to do over the next half an hour or so is look at Gordon's a specialist in dispute resolution and contentious issues and trying to work out sort of the best way for people to solve disputes, both commercially and in the civil world. So we're going to come up with some top tips and some ideas as to if you ever are unlucky enough to find yourself in a dispute, this is the sort of thing you should do. Does that make sense, Gordon?
That sounds good. Yeah, looking forward to it. I've heard a couple of your podcasts over the weekend, actually, so I hope I can do as well as some of the other people.
Of course you will. Of course you will. So let's kick straight off in terms of how did you get involved in dispute resolution? Because, I mean, as a young man, were you always arguing with everybody and thinking...
Well, I don't think I'm that confrontational.
No, I don't think
but there was something going on at work the other day, and we were going to have a meeting, and one of the fellows said, "Well, if you're looking for someone to avoid confrontation, Gordon's not your man." So I don't know how I became involved. Obviously, I went to university to do a law degree.
Yep.
Part of that, I did what was called a sandwich course, which isn't catering. It's you do actually after 2 years do a stint in a law firm, and I think it's just the kind of work you pick up then.
Yes,
it kind of drives it, and you start to get more involved. But I think really, as I've developed, I think it's really more that I just don't like unfairness, and if I feel someone's being treated unfairly, it really kind of gets to me. I'm sure there's people who've received letters from me and think that that's not the case, and I'm the one that's acting unfairly. But you know, it's that fairness, and I think in a dispute that really comes across.
And when I said at the beginning that you're commercial and civil, you're predominantly commercial. Is that just because of the position that Percival are in?
Yeah, so different civil litigators will have a different scope of work. If I've worked in other firms, you might cover a much broader spectrum. You might do property litigation as well as commercial contract work, internal disputes with shareholders and directors, but you might also have to do a little bit of employment work or personal injury. But at Percival, we're fortunate we've got a property litigation team, we've got employment team, so mine is very much on the internal disputes, your shareholders, your directors, also quite a lot of stuff with employees who leave, taking confidential information, taking customer lists, and then your contractual disputes, or things that arise out of share sales, so where someone sold a business and then there's been breach of warranties, that kind of thing. So, but it's quite a broad spectrum.
It is, isn't it?
Yeah, there's quite a few ways to get into a dispute, unfortunately.
Do human beings ever cease to surprise you in terms of the things they do to each other? Because presumably these are people who used to be in business together or working together in the main.
Yeah, I think whenever people go into business together, they think it's going to be great. And the same with any contract. I think people are enthusiastic about it, and sometimes that enthusiasm leads people to get started without actually thinking about the consequences as to where it can get to, what can happen. And that's when the problems start. I think, you know, there's some people who you meet and they say, well, I've done everything on the shake of a hand, and I think that was the way of the world for a while. I think that's brilliant if it works. If it works and people can, you know, get by on trust, and they just know that they've got the ability to resolve these issues. When it works, it's great. When it doesn't work, it's a bit of a nightmare to sort out, and that's when, you know, litigation becomes a problem. But certainly in terms of, you know, does it surprise me what people do? I think it depends how much they get wound up. I think, you know, one of the tips I would say is, and this is perfectly common sense, this is not a legal tip, this is try not to go around winding people up, you know, because quite often the dispute is not about whatever they're arguing. It's the fact that someone's got wound up over something, and then they're looking for their opportunity to strike.
Really?
And therefore, you know, neighbour disputes are a classic example where, you know, someone's been winding them up or whatever, and it may just be that the cat's been doing one on the garden or whatever. But if they then find that there's an issue at the land register and there's not quite the same sure who owns which bit of land, then they'll come in and
really, but actually it's about the cat,
and it could be something else, and the fact that, you know, things escalate. So once someone builds a perception up of somebody,
Yeah.
And I'm sorry, I'm getting into the psychology of it. I'm not
No,
a
I think it's really,
psychologist,
no, I think it's really important.
What I see from disputes is that I don't see that many cases where someone outright lies or someone makes things up and to try and force a dispute. I think people justify their position, and once a dispute is arisen, they recollect the effects, they recollect the facts or what happened to suit their perception of it and to try and justify their position. And therefore, if someone has wound them up or whatever, those are what influence their belief about how to approach this dispute and how to think. And that's what you're up against, and that's when it becomes a lot harder to resolve. You'll get a lot more passion and a lot harder to resolve disputes in, say, family disputes, and you'll hear circumstances of, you know, family disputes going to court over probate and all the money's being wasted on legal fees. We get the blame for that, obviously, but actually it's the parties. Sometimes they just can't let go. And I think it's a lot easier in a commercial situation where you've got, say, someone are in business and they think, right, well, I'm just not going to do business with them again. They can come to a commercial settlement. I'm not going to come across you again, and they can move on. In a family situation where they're going to see people at the next funeral or whatever,
it's hard.
So much harder, and there's so much deep-rooted. You know, people are sometimes influenced by what happened in their childhood and things, and who had the hierarchy as brother, and then that can come out in a dispute. And these family disputes can come up in commercial situations. You know, for example, in a say the father has been or the mother has been running the business. One of them dies, and then it's to come down to the siblings, and they've got to try and who's going to run the business with their sibling. And that's where you can sometimes get the tension and the conflict. So.
It's quite hard to handle that, isn't it? I had an old client whose father died quite suddenly and unexpectedly. He into his mind, had left shares then to everybody in the whole extended family because it was a very successful business. But the eldest son run it. And of course he got a lot of stick. And this poor soul was running it, and the board meetings, etc., the shareholder meetings were all about the dividend. Where I think it actually became really hard.
Well, I think also there's kind of this sense of entitlement, and people feel they're entitled to the same, but yet one person may have been doing all the hard work and things, and then they build up resentment because the other one's not contributing anything, and it just becomes a vicious circle. As the dispute rolls on, people think of reasons, and that's why the sooner you can get some advice, the sooner you can get the opportunity to identify what the issues are and maybe take some of the emotions out of it, and then get a strategy as to how to approach it to achieve what you're trying to get out of it. Because disputes can be an incredible distraction, certainly in the commercial sense, to you taking your key decision makers out of the business to think about things that can be quite draining. And financially, you know, there's a bit of a cliche in litigation. The only people who win are the lawyers, because it does cost a lot of money to go to court, and therefore, you know, the sooner you can look at options, and it might not be the best option to settle. It might not be, but at least as long as you've thought about it commercially and where you're trying to get to, you've got that strategy in place. Then you can decide how we're going to achieve that.
And would that be one of your top tips then, Gordon, in terms of seek advice early on? And I know from what you said earlier to me that not necessarily advice in terms of, right, we'll write somebody a stroppy letter and set out our position, but just advice for a strategy? Yeah,
I think so. I think what I find is people are usually emotionally involved, particularly if, you know, someone's wound them up. And that's not always the driving force, but if that is one of the driving forces, it's good then to just say, okay, if we can get an understanding, and we'll empathise with the situation, but also we're not there just to agree with what the client says. We're there to manage expectations, so we can get an understanding of the dispute and actually find out if it is about the fact that someone's taken some confidential information, or is it about that actually someone was a bit of a real pain in the bum for the 5 years they worked for them, and actually they want to lash out when they are about to leave and go and join a competitor and things. So we can try and get to the bottom of that, and then we can identify, okay, what's our story? Where are we trying to get to? Is that achievable? And then we can devise a strategy, look at what the budget is to try and get there, and also look at how the other side is going to react. Because we can write letters in a way that can be very strong. We can write quite passive letters and you know, quite conciliatory. But what I was saying earlier is Also, that letter does not have to come on a solicitor's headed paper. You know, if we decide a strategy and we actually think the other side is going to react badly to a solicitor's letter, or that's going to get them to get their lawyers involved and they want to become positional, we might write a letter that comes from the client on the client's headed paper.
Yep.
But actually we've had some input and it's all part of a strategy.
Yep.
What we find is if people have been running a dispute for a while, and then we're sometimes trying to undo some of the things that have happened,
Yep.
and it can be quite difficult to do that.
So you're better off with advice early, even if it's not saying I want you to write, or escalate the matter.
Well, I think you then decide on the best strategy.
Yeah.
Sometimes it's 100% the best thing for us to write, and sometimes it's got to that stage. But it's about getting a strategy. I think people are emotionally involved. It's stressful dealing with a dispute. It can be, and sometimes just us getting involved is just that shield as well. You know, I find that people, every time if they're involved with a dispute, so whenever someone's sending them emails, and every time they get one, they think, oh, blimey, particularly if they're trying to get on with work, trying to run their business, and suddenly that email's coming in from this nuisance, then we can act as a shield. We can take that, because once we're instructed, all communication should come through us. Then they should right to there. And then you can start to say, okay, right, I've got this email, don't worry about it. It's not particularly bad, but is it a good time to have it now and we'll talk about it, or do you want me to send it later in the day?
Yes.
And it just manages the situation,
Yeah.
and we kind of can share some of the burden of it. I find that if people come in with a problem, and sometimes they've been worrying about this problem for weeks and months and things, they come out into the office, they're worried, they'd like to get it all off their chest. And that can be quite cathartic sometimes, and then you develop a plan, and you can see the weight lifted as we go. Right, we've got a strategy to deal with this now.
You're not on your own any longer.
Yeah,
you've got some professional help, haven't you?
Yeah.
What are the common commercial disputes that you see, Gordon?
Yeah, I think there's a few that come up a lot.
Okay.
You'll get your internal shareholder disputes where people have gone into it, with
a shareholder agreement.
I think the advantage of a shareholder agreement is if it's been drafted properly, you've anticipated some of the things that go on, and it's the same with any contract, and when you're looking at any situation, you're trying to anticipate what could go wrong and put things in place while everyone's calm and while everyone's on good terms, and it makes logical sense to do this, rather than doing it when you're actually in a conflict situation and trying to resolve issues then. Because generally, at the start, people can anticipate it and it makes sense and they do things. But if you haven't got that agreement, you haven't sat down and do that, then you may be some misunderstanding as to what party's going to do. And in any contract, so contract disputes come up quite a lot. And again, it can be where someone's been instructed to do something, the enthusiasm to do it, let's get on and run this. We've got this great piece of work, let's get on and do it. Without identifying, I think one of the key tips would be, if you're going into any agreement with anyone, identify what the key obligations are for both parties. So who's doing what? So you know at the outset who's doing what. And just record that in some way. Yes, an agreement is one way of doing it, but as long as there's a record of who's doing what, because generally then when you get to something going wrong, then you've actually not got to spend the time arguing about whose responsibility it was. It's then, have they done something right or doing something wrong?
Okay.
I think if you get into a court action and there's a dispute about who's doing what, you can spend a lot of money arguing what the actual contract was before you start identifying who's done right and wrong, and that's when litigation gets expensive. So those are a couple of examples. Another thing that comes up a lot, I get a lot of instructions on competition things where people do leave, join a competitor, take confidential information, and again, those are the things that really wind up clients and businesses, because they've been paying someone's mortgage, they've been giving them a job and things, quite often help them with training, done all sorts, and then they just go and sometimes naively, sometimes I think people aren't aware of the significance of their actions. They sometimes think, oh, these are my customers and I can take them, or I've worked with so and so for a long time, so I'm entitled to take them with me, and they go and join a competitor without necessarily realising how irritating that's going to be and how potentially damaging it can be. So that comes up quite a lot. So you get your internal stuff, your external, and then obviously the property litigation team will get people problems over leases and problems with landlords, and just general customer disputes, suppliers letting you down. So and that's where again it's important when you're looking at your contracts or looking at what you're trying to do. If you're identifying what have I got to do, what's in my control, what can I control, and then if you say you're going to do something, do it.
Yeah.
But if something's outside your control, you might rely on subcontractors.
Yes.
You might be relying on suppliers. For example, Brexit.
Yeah.
We don't know what's going to happen, and whether if people are relying on goods coming in from abroad and they're not sure about their supply line, what's our plan to deal with that? How are we going to deal with it so we can still meet our obligations to our customers? Because if you're in a contract to do something, the customer's not going to be bothered. You say, oh, well, so-and-so has let me down.
That's irrelevant, isn't it?
Yeah. So you've got to get your protection in place. So
contracts are important right from the word go in terms of understanding, as you say, your obligations and what's within your control.
I think that's it. I think in any business, you want to look at the things that are going to go to the heart of your business. What's going to cause me damage? And then do a risk assessment. So in terms of contracts, I'm going to be doing a contract. And you will then start to realise that actually these things come up a lot, and that's why you need your terms and conditions, so you anticipate what are the problems, and you get the terms and conditions in to protect your position. But you don't then necessarily have to apply those to the letter of the law all the time. And so a classic example is just in cash flow. Cash flow can be really important, really go to the root of a business. You want a really robust procedure in place. But if you've got a really good customer who's got a genuine excuse and it just can't pay you this month, then you might be a bit more lax and a bit more relaxed about it with that customer, because you've got a history there, and they've never let you down, and when they come on the phone and they say they're
it's genuine.
Can't do that. Whereas you also know with other people it's not, and you need to have that. I talk a lot about carrot and stick. Your stick is you've got your terms and conditions, you've got the ability to take your court proceedings and things, but also you might have the carrot of giving someone a slight discount for prompt payment, or some incentive to pay to help the relationship. So.
And how easy? It sounds a leading question. I don't mean it to be, but how easy is it to actually determine what damage has been done? So in terms of if you were trying to claim damages or in a dispute, I can imagine that's really quite hard, isn't it? Yeah,
and that's a really important factor, because some people get really wound up over a situation and they want to punish the person for doing something wrong.
But that's not the way the law works, is it?
No, but you've actually got to have suffered a loss. So you've got to be able to establish that you have suffered a loss to be able to recover damages for breach of contract. So and you've also got to take steps to mitigate that loss, which means you can't just let the situation drift.
So from the moment I knew about it, I should, as you say, take steps.
If there's a reasonable opportunity to actually put it right, but that can get into really grey areas and things. So for example, in a building dispute, someone lets you down and doesn't do the works on time. At what point do you actually terminate the contract and go and get someone else in to bring it to do the works, and how much should you be spending, and can people actually afford to go out and do that themselves, and therefore you can get into lots of arguments over whether someone's mitigated the loss or not.
It's quite a grey area, I can imagine.
And then also you can find that the actual liability issue is straightforward, but then the arguments can all be over the losses, and sometimes it's also the element of causation. So some people might be saying, well, actually this has caused me a loss in this area. I've lost this contract, and I was about to secure this contract here, and this was going to be the thing that made us, and and it's then actually, is that foreseeable? Has it actually been caused by that? Were there other things you could have done to just go and make that happen? So the losses element is a really big part of it.
Is it?
And those are the things you've got to think about.
So you hear a lot about mediation. And is mediation compulsory? I mean, is it, or is it just frowned on if you actually went to court and refused to mediate? I
think what the courts talk about, and we have some pre-action procedures that we should follow. So for specific types of dispute, you have an actual protocol. So for construction and engineering disputes or professional negligence, there's an actual protocol, and there's a number of them. But also there's just a general all-encompassing practice direction for pre-action conduct, which encourages, before you start court action, you should at least set out the circumstance of your grievance.
And that's what the pre-action is to give me the notice to say, actually, this is specifically what's wrong.
These are the issues, and if you don't respond to it, then we're going to go to court, and that's what you're required to do. But the court also says that you should consider whether alternative dispute resolution, which could include mediation, but it could just include picking up the phone and speaking to the other side and saying, we've got this issue, what do you propose to do about it? And there's other options like adjudication for business, for construction disputes and arbitration. So there's other mechanisms that can be used to resolve disputes. Sometimes if you got a factual issue about something, you can just go and get one person to determine that and say, right, we'll agree to be bound by the decision of an independent third party. And so there's different strategies that you can.
And that's quite often in shareholder agreements, isn't it?
Yeah, and sometimes in your agreement it will have provisions about and in contractual disputes as to what you're going to do in a dispute. So you've got your dispute resolution clause, and it prescribes in advance what you're going to do to try and resolve it. And sometimes that's both parties agree to do it, and that can save a lot of problem, because it means you tackle the dispute at an early stage when it's. He's usually saying, within 28 days we'll do this or whatever. So that parties can actually approach it, and they'll usually get a bit of advice at an early stage to say, right, I've got to do this. So it means you tackle it rather than it drifting for a while. And when things drift, those tensions build up.
It gets too emotional, doesn't it?
Yeah, and then people start to pursue. So, but mediation is a really good process, and why mediation works is there's an independent person in the middle.
Are they professional?
So they don't have to be lawyers. They can just anyone can go and do this course and qualify as a mediator. There are obviously different skills that that are benefit. And we're lucky we've got some really good local mediators. But there's lots and lots of them about anyway, and you can go for horses for courses. If you want someone who's relevant to a property dispute, there's people with property experience. Lawyers generally are quite good at it because the consequences of not settling is usually some kind of court procedure, so they usually have got experience with that, and they're quite good at it. But the idea is you will go. I think the history behind it is people used to get to the court door and the parties had never met each other or spoken about this dispute at any stage. And the barrister would just get together before the trial. There's usually be a delay. There's more than one case listed, and therefore you've got a bit of time. People would speak and then say, all right, we can solve this.
Really? So you shouldn't have got to that level.
Yeah, and therefore by bringing the parties together, and there's a kind of psychology between, actually, if you go into a meeting to try and find a solution as opposed to going to court, you're going for a fight. So you go there, and the mediator sit you down separately in separate rooms. He comes in, finds out about your case, but anything you tell him, he won't tell the other side without your consent. So you're
not in a room together, you're in separate rooms.
And then you can be a lot more open with the mediator about the issues. And you'll tell him stuff that you don't tell the other side necessarily. And he's heard from both sides then, so he's got a feel of what people's approach to this is. But he also builds up your trust a little bit, because he's really nice and he's really listening to your case. Whereas if you tell him to the other side, though, I'm not having that, and things, he's actually really showing interest. So the clients think, he's on our side, isn't he? And they get that, so they can open up a little bit. And then same with the other side, and then he can then play devil's advocate. But when he's putting the points to you, because he's been listening to your case and things, people will listen to it a bit more and take on board. Not always, but so it works. And then.
And would you normally, as a lawyer, be involved in the mediation?
Depends on the value of the dispute. Depends on
but if
what
I
the
wanted
issues
you to
are.
be, you would be.
Yeah, but generally we're there. We're there to provide, because the mediator's not there to give advice.
No.
The mediator is not bothered who gets the best settlement or not. He's there to try and help you resolve that dispute, to save you, and it's for you to decide whether a resolution at that mediation is a better alternative to your options of going to court or whatever other options there are. So he's not there. He's just there to help you get a deal, and whether that is closer to one party or not. I've had some mediators say at the start, if both parties come out equally unhappy, I've done my job. Which is not really selling the process.
But actually it's a pretty good description, isn't it?
And I think what they'll also say is, if you wake up tomorrow and are just relieved, that this has gone away. What I often say to clients is, if in 6 months' time this is still gnawing at you and you can't let it go and it's still winding you up, then perhaps the settlement is not what you wanted. You need to. Some people need their day in court. They need to be heard. And we can have 4 or 5 clients with the same problem and want to approach it in different ways. Because people are different, and that's a big part of litigation, is knowing the parties, knowing their approach to things. But just on mediation, it's a really effective process because it gets people there. They go with the mentality of trying to settle it, and 70% of cases will.
It's of a high percentage.
And then even if they don't settle at mediate, I don't know how up to date these stats are. Maybe a couple of years ago, well, I can't see that they would have changed. And quite often, even if people have been to mediation and had this, sometimes it just takes the fight out of the thing, and actually it settles soon after. The dust settles, and they just think, actually, sometimes. I've been to mediation where actually people have done business together after, and they say, actually, they're not as bad as I thought they were, because they've built up these perceptions of people or things.
Taking a position.
And actually, they find that people actually can be quite pragmatic and things. Not always. I've also known situations where the parties absolutely hate each other's guts. You would not put them in the same room together, and they never want to see it again. So. And
I mentioned this before about a case I know of where. They went to mediation knowing they were going to go to court, well, assuming so, and once the mediator made his opening statement, my guy just said, well, I'm off, I'm not participating, because I think you can't disclose, unless you willingly do so, what happened in the mediation to the court.
Absolutely. So the courts will consider whether parties have mediated and can make adverse costs decisions if someone refuses to mediate.
So if one side says, look, I'm not interested,
then what they'll tend to do is you have to write a statement as to your reasons why you're not going to be considering mediating, and the judge wouldn't see it until he comes to consider the issue of costs, and then he can look at it at the end and say, well, once the judge has made his decision, the normal rule in costs, and I will come back to your question there, saying that the normal rule on costs is that the losing party pays. But that can be changed if parties have made an offer of settlement or have acted in a way, and the court will listen to what offers have been made and also what attempts people have made to consider mediation and whether they've approached it. In terms of the mediation itself, you enter into an agreement with the mediator draws up an agreement, that anything that's said there is without prejudice. And without prejudice is something we use a lot in litigation. It means that you can say things that can't then be taken as and used in the court proceeding. You can't say, oh, well, you said this or you that. And it's essential to mediation, because if someone's making offers and trying to settle it, they don't want the other side saying, no, well, you did say this, that. Yeah. So you can't then be questioned about it. So people will use mediation tactically. There will be some people will think, well, actually, why do I want to compromise? Because the expectation, if you're going to mediation, you're trying to settle something, there's going to be an element of compromise by both parties, and it's virtually nigh on impossible. I mean, sometimes people will go to mediation just to eyeball someone and say, I'm going to break you, I'm going to mount bankruptcy here and things like that, and people will come really aggressively and do that and then walk out. You know, so you do get different approaches to it, but the idea is that you go in there, because it's an expensive process in itself. It's there as a mechanism to try and achieve, and that's why the stats are quite good, that it is quite effective.
And good to draw a line under things, isn't it? Because if you were, I read stuff in the press and things. If you had a dispute that was going to court, I mean, it's going to be a long time before it ever gets heard. Or so in the meantime, it's festering and eating away and diverting attention and emotion and everything else, isn't
it? The courts are still heavily overrun, so it can take a while to get court dates listed and things. It's expensive. Even the court fees went up significantly in the last couple of years. So now, if you've got a dispute up to £200,000, you've got to pay 5% of the court fee, which is, for a £200,000 dispute, that's £10,000, which is a significant outlay at the start.
And that's just to get it to court.
That's just to get into the court to start the process.
Really.
And if you are in two minds. So in the past, what people would do is, you were talking about losses.
Yeah.
If you thought you got a claim, you'd try and put it at the highest. You'd try and maximise it to try and put your claim at its highest, because if you're going to go to a negotiation, you want to start from a high point.
Downhill.
Yeah, absolutely. But if you've then gone on record and put your case in, you've then got to stump up your £10,000 court fee.
And did that never used to be the case, or was that?
So no, the court fees would have been not at a percentage.
They were just fixed.
Yeah, and there would be at an increasing rate, but not to that extent. So it's a huge amount. And then also, it's quite difficult. If you want to bring a claim against someone, but you're a bit concerned that they might be insolvent, or you're not sure.
Yes.
You've got the right in principle. You can get a piece of paper with a judgment. You got a piece of paper with a judgment, and you get your £10,000 court fee on the top. But if you're not going to recover that, then that's quite a big outlay. So you've got to look at your strategies as to how to approach it. So,
what other tips would you give people then? So we've had seek advice early, just so you get your strategy right. Think about mediation. Try and remove some of the emotion from it.
Yeah.
What other tips can you think of, Gordon? Do you think actually?
I think some of the things we touched on. Don't go pissing people off. Basically.
Don't wind people up deliberately.
Yeah, because I think even if you get into a dispute, if you've dealt with your customers well, I mean, it's a common thing, is it? And you think about yourself. If someone does something wrong or whatever, you get into a comment. If someone causes a problem, you accept it. That people go, we're not perfect, and things can go wrong.
It's what they do about it.
But if someone then takes steps to put it right, you can actually come out with a better opinion of that person than had they not got it right in the first place. And therefore, if you deal with people in the right way, it's a lot harder for someone to instruct us to really go for the jugular if they actually quite like the person. Or if they want to do business with them again, and actually it's not breaking down. So it's just talking in cliches, but you don't burn your bridges with people, and actually try and get on with them. It will help. Might not stop the dispute happening in the first place, but it will help you resolve it. And if you build up your credits with people, and then on that as well, do your due diligence on people that you're going to do business with.
Okay.
Because again, if you are looking at, contracts. If you know someone and you've been doing business with them for a few years, you might then relax some of the things that you do. You've still got your terms and conditions in the background, but it might just be a lot easier. There's a lot more trust there, isn't there? And that you're going to sort things out. Whereas if you might have slightly different approach to someone who you're dealing with for the first time. But if you're taking on a new supplier or whatever, you just want to do your due diligence. If you're relying on them to perform your contract, you just need to be sure that these people are who they say they are, and they're not going to let you down. Otherwise, it can come back to bite you on the bum, really.
It can be painful.
And get your terms and conditions in. So one of the other things we talked about was that understanding what you've got to do.
Yes, and what our obligations are.
And so you know exactly what you're doing and know what the other side's doing, and get that recorded. All those things help. The worst disputes are family disputes or disputes where people are really wound up and they don't want to give ground, or where there's no agreement. And because you've got to spend all the time on, well, who said what? What was this? What was agreed in the first place? Well, no, you were doing that. No, we were doing that. And you can have, counterclaims come in and then I think the emotions. So making sure that, as I say, you devise your strategy is really important.
Really early on. So you've always got a mind to the end game, really.
Yeah. And that strategy can be fluid and it can move. And you've got to try and anticipate what response you're going to get, how it's going to go. And that's where it's really important we work as a team. So, we're bringing the legal knowledge and the knowledge of the procedures and our experience of dealing with disputes and how people respond. But we don't know the individuals. The clients do know the individuals. And the more we get a steer of actually, well, what tone should we put on this letter? Because some people will respond to threats in different ways. Some people will back down. Some people will say, all right, bring it on. And therefore you've got to think of your approach and things, and that's where the experience comes in. So our experience and what we bring to a dispute is not just our knowledge of the law, it's our knowledge of
having done these so
situations,
many times,
how people respond in that situation, how to approach it, and getting that strategy, helping people to decide, and also helping people decide themselves. Sometimes people come, they're not sure what they want out of the problem. They're not
sure
themselves, or certainly if someone's making the threat against them, they're not sure how to deal with it, how to respond, and therefore.
Well, I think the big learning point for me from talking to you today, Gordon, is that seeking advice, isn't it? Because these are very emotionally draining events, aren't they, when they happen? And actually you can feel very isolated, and it always felt a little bit to me beforehand that involving a lawyer sort of escalates matters, whereas from what you're saying it helps you offload, think about the law, devise a strategy, and use it and work as a team to say, actually, even if it's not going on your letterhead, to say, how do we get a resolution to this?
Yeah, I think the cynics listening would think, oh, what a surprise, it results in getting advice.
No, they wouldn't think that of you.
No. But I think we are seen as a last resort quite often.
Yes, which is a mistake, isn't it?
Yeah, and actually, the time you should be thinking about is before there's ever any thought of a dispute. It's back at when you set up your company and your shareholders agreement, get it in place then. When you're doing your contracts, and what we'll find is that people don't like doing that stuff. They're good at running their business. They're good at the stuff. They want to get on and serve their clients and do the thing.
Yes.
Well, I mean, I've seen all sorts of things where people have actually gone to the point of instructing the lawyer to draft the agreement, but then they've not signed it or whatever because they've just got on and they got distracted. And there may be this 20-page agreement, not that it needs to be necessarily, but there may be a thing, and there may be just one or two points that are just sticking points, and therefore they've not nailed it down, and they've just carried on. And or we've had examples of people who've got terms and conditions of someone who's an employee who's about to leave, and they may have the restrictive covenants in there. They're saying, oh well, and that's very much dependent on the industry that you're in as to what's reasonable. So I've seen them where the lawyers put in, it could be 3, 6, 9 or 12, or they've left a blank for them to insert, and then they've not gone to the trouble of just doing that, because genuinely they just want to get on and help people and do the right thing. But actually, these documents and these procedures are there, and if you've spent the time, invest the time in getting that right, it will help you.
Yes. It just feels counterintuitive, doesn't it? The time when we're excited and we're doing stuff together and we've got this new business idea or a great employee, to try and think what happens if. It's a bit like doing a prenup, isn't it? I can understand the logic, but I can also understand how that's actually quite hard to do. And it's almost like saying, right, we're going to fall out at some stage. Yes, that's right.
So let's get some ground rules now, which is not a good starting point.
No.
And I understand that. And I think as lawyers we need to be a bit more reflective of that and make sure. But it depends on your attitude to risk. And at that stage you might think, well, actually the risks aren't that great when we're first standing up. Not that great, but we need to review it in 12 months' time or whatever. But actually, as long as you've considered it and balanced the risk, and it's about what are the things that are going to go to the root of my business. Do I need to put some protection in place at this stage? And those can be simple things like your cash flow things. And, it can be cyber security. But also, that's not all the answer either, is it? You put these policies in place or these things, but people are human and people will let you down. So you've got to train your staff and things like that. I think communication is also another big factor and a tip. I'll give you a personal example of I've told this story a few times. I won't mention the plumber involved. He was a nice guy, but we needed some work done in our bathroom at home, or in our ensuite at home, and we'd waited a while to do this, and we'd seen a couple of people, but eventually I came across this plumber. I'd done my due diligence because I met him at a stag do. But he was a nice
decent fella. Drank well.
But he was actually a friend of my brother-in-law and stuff, and nice guy. And he actually, in the run-up to everything that we did, he was brilliant. He was really easy to use. He was in touch with a place where we could order all the things we needed. His price was sensible and things. And on the morning he came to start work, he got ill that day, and he had to send his young mate along to start the works, who came to our house and ripped out our bathroom roll and our ensuite. And And you can do all these things. You can have a brilliant relationship with the customer, do everything great.
Wow.
But if you don't communicate with your own staff and do things,
so you literally ripped out the wrong bathroom.
I think it just says a lot about the state of our bathroom at the time. Looked at the state that it needed ripping out. So communicating with your people, so that your own staff. Because actually, it's the thing, isn't it, where people have one man, and then it's having that trust to take someone on who's going to live up to your standards and things like that.
It's a hard one.
Yeah, but communicating with people so they know. You've signed up to this contract, but if you don't tell your staff what they're doing and what the terms of that is, then you can get into difficulties and things.
Well, it's been fascinating, Gordon. We've spoken for just over 40 minutes, would you believe? It's flown by, isn't it?
Indeed.
And some really good insights. How do people get in touch with you, Gordon, if they... And I would urge people to. I've known Gordon a long time. You won't get a more decent lawyer than Gordon. So how do they get in touch with you?
Well, thanks for that, Neil. House Percival have a website. Okay. So if you go on to www.housepercival.com, and you can then find people that way. I'm on LinkedIn. Okay. So search Gordon Simpson. I don't know how many Gordon Simpsons there are out there, but I'm not searched myself. But find me on LinkedIn that way. That'll be fine.
Okay. Well, thanks very much indeed for your time, Gordon. It's been brilliant. And thanks very much for everybody for listening. Until next time, goodbye.